Hello, everybody. Let me extend a warm welcome to all participants in this panel this morning. I see we have 32 participants, and I'm hoping most people have had a chance to join. We'll just begin perhaps with our welcoming words in order to start the discussion off. We're looking forward very much to a fascinating and an interactive discussion today. My name is Madeline Garlick. I am Chief of Protection Policy and Legal Advice in the Division of International Protection of UNHCR, the UN Refugee Agency, and it's a pleasure and a privilege to be chairing this panel this morning. This thematic panel is on externalization, responsibility sharing, and the Global Compact on refugees, focusing on the relationship between existing and emerging externalization practices on the one hand, and the promise of responsibility sharing that's contained in the Global Compact on Refugees, or GCR, on the other. More specifically, this panel is going to address the relationship between binding rights and obligations, notably the right to leave one's country and to seek and enjoy asylum, and the GCR, and looking specifically at gaps in protection that may foster harm and responsibility shifting to other states and other actors. It's going to look, secondly, at the promise of the GCR to achieve more equitable and fair responsibility sharing between states in light of the pledges that have been made during the 2019 Global Refugee Forum and their relationship to existing and emerging externalization practices. In a third place, it's going to look at the pitfalls of current externalization practices, focusing in particular on Southeast Asia and on Australia and Bangladesh, as well as the potential for the GCR to support a shift towards more protection-oriented responses to large-scale refugee and migration situations, including the Rohingya refugee situation. Before we begin, I'd like to recall that this panel emanates from the Refugee Law Initiative's Working Group on Externalization, convened and led by Nick Tan, who many of you know. And after today's event, if anybody's interested in the work of that working group and becoming involved in it, please feel free to contact Nick, and I'd encourage him to put his contact details in the chat for that purpose. Before we introduce our speakers, I'd just also like to say that I'm particularly pleased to be moderating this panel from UNHCR's viewpoint, because the topics that we are addressing are all extremely important issues for us in our work today with states and refugees worldwide. Responsibility sharing is clearly a critical principle emanating from the 1951 Convention and its call for international cooperation as a key means to address refugee challenges. The Global Compact on Refugees evidently is a crucial focus for our work, having been agreed by the UN General Assembly in 2018 and providing a very important frame for us to work towards ensuring more effective implementation of international commitments to refugees and protection worldwide. And thirdly, the issue of externalization is also one on which UNHCR has taken a public stance in recent weeks, as we have addressed some of the challenges we've seen around new proposals that have emerged from some countries in Europe to look at transferring responsibility for asylum seekers to other countries in ways that suggest inadequate safeguards may be in place to ensure respect for their rights. So we think this is a particularly timely and important discussion. So I'd like then to turn to our first speaker today. This is Emilie McDonald from the University of Oxford in UK, who is going to talk to us about the right to leave, to seek asylum, and the Global Compact on Refugees. Emilie, over to you.
And it would be good if I unmuted first. Thank you so much, Madeline. It's really, really exciting to be part of this panel with Dr. Garlick and my fellow presenters. So today in my brief discussion, I will be presenting how the right to leave is a key right and a key avenue for helping to dismantle the externalization strategies of states and the EU, how it can shape more human rights and protection-oriented refugee and migration policies, including during implementation of the Global Compact. So turning first briefly to the phenomenon of externalization. Destination states worldwide, predominantly those in the global north, for example, Australia, North America, the EU, employ a range of practices designed to prevent migrants, including citizens of partner states, leaving the state they're in and their irregular arrival at state frontiers. Now, this is done through visas, carrier sanctions, interceptions on land and at sea, so including pushbacks and pullbacks, offshore detention, as well as transfers to safe third countries. And we've also now seen a move to more remote forms of migration control, so destination states pressuring and enticing states of origin and transit to perform migration control and stem irregular migration on their behalf, so through a carrot and stick approach. And so this involves extraterritorial conduct, partnering with states of origin and transit, and outsourcing to private actors and international organizations, so IOM, Frontex, NATO, for example. Now, externalization is often seen as preventing migrants entering state territory and claiming asylum, so-called non-entree measures. However, many of these practices are directed at containing migrants in states of origin and transit, preventing them even embarking on their journey, at least lawfully or safely, as well as suppressing onward movement. So for example, the initial visa requirement, transit visas, the sanctions penalising carriers, so airlines and ferry operators for transporting undocumented migrants, and pullbacks at land and on sea. And this interferes with and arguably violates the right to leave. So although the right is often overlooked and neglected, it is enshrined in almost all major universal and regional human rights instruments. So just briefly, Article 12 of the ICCPR provides that everyone shall be free to leave any country, including their own. And this can only be restricted when provided by law, necessary to protect specified legitimate aims, for example, national security, public order and public health, and consistent with other rights in the ICCPR. And just to point out, while the right applies to everyone, it is of particular importance for asylum seekers. So if we read the right in its normative environment, we see on the one hand how the right protects an individual's right to leave to seek asylum and search for a state to admit them and to offer potential protection, with non-refoulement and collective expulsion obligations on the other hand, triggering temporary admission for individuals, at the very least, to access asylum procedures and safeguards. So turning now to the Global Compact, in particular the GCR. Several scholars, for example, Catherine Costello, Vincent Shatai, Alexander Alenkov, have drawn attention to major omissions in the Compact, and I'd like to point out several of them. First of all, the GCR fails to expressly acknowledge the right to leave, as does the GCM, or its significance for asylum seekers. Although, of course, the GCR is grounded in the international refugee and human rights regime and their instruments, and it does refer to the right to seek asylum, but only in a footnote. Second, it fails to oppose externalization strategies and the way such practices frustrate departure, access to territory, and international protection. And the UNHCR note and annex that Madeline referred to are particularly welcome in this regard in terms of calling out such practices, but it doesn't mention the right to leave directly. Relatedly, a significant issue is how the GCR and refugee regime more broadly does not question how visas and carrier sanctions obstruct lawful refugee movement, fostering dangerous travel, increasing trafficking risks and smuggling, or leaving asylum seekers trapped in precarious situations or in limbo. And I believe that the problem does continue in the UNHCR annex. Visas clearly obstruct the right to seek asylum, denying lawful routes with only small resettlement numbers and ad hoc humanitarian corridors, while carrier sanctions, the risk of refoulement is well known in this system. So there's a level of contradiction here, with the GCR seeking to avert and resolve large refugee situations, ease pressure on host countries, achieve better responsibility sharing, with the GCM, for example, seeking to facilitate safe, orderly and regular migration, with Objective 7 in particular seeking to reduce vulnerabilities. But then the Compact does not urge states or the EU to cease externalization practices that limit lawful movement or shirk and shift responsibility. The Compacts arguably seem to normalize or at least unintentionally support containment and externalization, which is unsurprising, I would say, potentially in the GCM context, as it was concluded by states directly. Going forward, I argue that to effectively strengthen international cooperation, achieve responsibility sharing, and improve the protection of asylum seekers and migrants, aims which underpin both compacts, states and the EU, Frontex, IOM, for example, must give due regard to the right to leave when implementing the compacts, as well as other agreements and compacts being developed going forward. Having already reaffirmed their duties to respect, protect, and fulfill the human rights of all, end exploitation and abuse, and discrimination of any kind, states in the EU must move away from focusing predominantly on containment and externalization, to first of all making good of their commitments to increase the availability and accessibility of resettlement, complementary pathways, and those for regular migration. So this would allow people to leave and move more safely. And I will just add to this, there's also a need to strengthen regional free movement regimes outside the EU, for example. And this should occur alongside ensuring development aid to states of origin and transit is not conditional on stemming irregular migration, as we are currently seeing in partnerships between destination states and states of origin and transit. Rather, development aid should be solely addressed at conflict prevention, post-conflict recovery, mitigating and addressing climate change, poverty, etc. Of course, there's not an extensive list, but lastly, I'll refer to ceasing push and pullback practices. So replacing pushbacks and pullbacks with genuine rescues, whether at sea or on land, and a resumption of dedicated search and rescue services by countries and organisations that have previously replaced them with securitized, militarized operations. And as many scholars and NGOs of late have been pushing for, there is a real need for robust and independent border monitoring mechanisms to ensure migration control activities uphold human rights. When integrating the right to leave, including to seek asylum and protection, into policies and practices, this would arguably do three key things. It would see the dismantlement, or at the very least, I would say a reduction of externalization practices inhibiting departure and pushing migrants into irregularity and harmful situations, would strike a better balance with state sovereignty and the right to control entry, and promote greater responsibility sharing, increase the agency and protection of asylum seekers, fostering a regime that reduces the burden on host states, is more human rights and refugee law compliant, and less discriminatory and unequal. And just to conclude, I see this as necessarily requiring strategic litigation and advocacy on the importance of the right to leave and its relevance to externalization and the compacts. Thank you so much, and I look forward. I'll hand back to Madeline now, and I look forward to hearing the other contributions.
Thank you very much, Emilie. Yes, fascinating food for thought that you've set out there for us. And I look forward to the discussion where there'll be an opportunity also for the observers to take part. I should have mentioned, of course, before we began that indeed participants are encouraged to put comments or questions into the chat, which we will subsequently address in the Q&A session after our speakers. Let us move now to Elizabeth Mavropoulou, who is at the University of Westminster in the UK and who will speak to us on fair responsibility sharing, responsibility by capability, and the Global Compact on Refugees. Dr. Elizabeth Mavropoulou, over to you.
Thank you, Madeline. And I'm very excited to be here in the presence of colleagues and of course of UNHCR. So in my 10 minutes presentation, I will be discussing responsibility sharing under the Global Compact on Refugees, reflecting on how it is conceptualized in terms of scope and modalities. I'll be highlighting some useful developments in the area of responsibility sharing, but also identifying areas of concern in the structure of the compact and the conception of responsibility sharing it ascribes to. Finally, I will be suggesting areas where the GCR can improve and conclude with a reflection to what extent the GCR can contribute towards fair and equitable responsibility sharing and whether it can fill the long-standing responsibility sharing gap of the Refugee Convention. Without going too much over well-trodden ground, the GCR, even if non-binding, is the latest compelling evidence to the claim that protecting the refugees and finding solutions to their plight is a common and shared responsibility of the international community as a whole, and specifically that of states. As the compact put it in its opening statement, it is a common concern of humankind protecting the world refugees and finding solutions to the plight that depends on responsibility sharing. The GCR endorses a conception of responsibility sharing as a partnership of states of origin, asylum, transit and destination in what it terms a whole of society approach. But let's move now into what kind of conception the GCR ascribes to. It seems to promote a rather broad conception of responsibility sharing, both in terms of what can be contributed, ratione materia, and who can contribute, ratione persona. Traditionally, responsibility sharing has been defined or understood to be financial and physical sharing. Financial sharing modalities have been UNHCR, financing UNHCR's budget, financing asylum capacities and costs in host countries, or contributing in development aid. Physical sharing modalities have been around refugee admission, be that resettlement in third countries, and more recently, complementary admission pathways and legal access to third countries with a purpose to actively relieve host states. So the GCR, in an exhaustive list of areas of support, which we can find in part 2 and part 2B of the Global Compact, widens the scope of responsibility sharing modalities and hence the tokens of responsibility sharing commitments states can pledge for. States can pledge to policies, accession to refugee law instruments, asylum capacity building in host countries, infrastructure, technology, material assistance, research, legal aid, political support to countries of origin through diplomatic and other channels, and in tackling root causes. In terms of who can contribute, whose responsibility is at the end of the day, well, the Global Compact says that it's not only states. The GCR endorses a whole of society approach where contributions to protection and solutions can be made by the private and corporate sector, NGOs, researchers, cities, municipalities, universities, local authorities, faith-based organizations and communities, refugees and diaspora. All the above stakeholders can variously contribute individually or in partnerships. Most importantly, I would say the GCR also promotes a normative conception of responsibility sharing in the sense that it seeks to answer the question on how to share this common responsibility. It promotes a notion of responsibility by capacity or capability by calling states to contribute on the basis of their existing contributions, capacities, resources, and levels of development and national priorities. And to some of us, this reminds us the language of common but differentiated responsibilities in international law. The GCR also acknowledges that the developing and least developing countries undertake the greatest share of this responsibility, and their needs, therefore, need to be taken into account. This reframing of responsibility sharing as responsibility by capacity is a welcome starting point from which we can begin to reverse the responsibility by proximity that has been the norm in the way the Refugee Convention is structured in the absence of a responsibility sharing obligation codified in international law. A year and a half after the first GRF, the Global Refugee Forum, the dashboard that hosts the about 4,400 pledges paints a somewhat disheartening picture when it comes to state concrete commitments to responsibility sharing, particularly those in relation to refugee admission. This needs to be looked against the ramification of the COVID-19 pandemic that still sees mobility restrictions, border closures and budget cuts, derogations from refugee laws and principles, and the continuing externalization practice of some states. Some of the concerns that arise in relation to how responsibility sharing is envisaged in the GCR and how it so far has been implemented are the following. First and foremost, a whole of society approach is welcome, but it risks diluting that the primary responsibility for international protection under international law rests on states, and it shall be provided through the institution of asylum. Community and private-led sponsorships as complementary pathways must be additional to state-sponsored resettlement and state-sponsored refugee admission. States, particularly of the global north, need to open up avenues for refugee admission. The private sector has contributed more at the Global Refugee Forum than all states combined in terms of complementary admission pathways through the means of labor mobility schemes, academic sponsorships, etc. Secondly, there might be a risk long-term of increased privatization of international protection responsibilities where states rely on the private sector while doing the minimum and pursuing their externalization and restrictive asylum policies. Third, to my view, the GCR promotes a too broad scope of responsibility sharing. Most states' pledges have been too vague and can barely be concretized in numbers on refugees being resettled or access to protection through complementary pathways, so as to actively relieve developing and middle-income refugee host states. Some pledges cannot even be said to fall within responsibility sharing under the Refugee Convention. For example, pledges on using diplomacy and other means in tackling root causes. The Refugee Convention does not deal with the causes for flight, essentially delimited the scope of international protection to palliative protection and solutions. Therefore, anything related to the UN prevention agenda should not fall within the responsibility sharing in international refugee law. Although a bottom-up approach, namely nationally determined contributions, is not necessarily problematic, vague and general pledges are difficult to assess, let alone measure, in light of the indicators framework developed by UNHCR. Thirdly, development aids and increased debt of the developing and middle-income refugee host states remains an issue of concern, particularly if looked in light of fairness at an in-state relations. Yes, the World Bank did pledge 2.2 billion under its concessional financing facility, which extended concessional lending to middle-income countries. And the 2.2 billion complements efforts to provide support to refugees and host communities. But we should bear in mind that concessional lending encourages austerities in countries with already limited capacities. We saw that in the case of Tanzania, which withdrew from the comprehensive refugee response framework because it would have to borrow money to protect refugees. So an idea on fairness towards the developing and least developing countries that host the majority of refugees on behalf of the international community warrants that refugee targeted development aid is additional to existing earmarked development aid budgets. It also warrants that in some cases, development aid should, to a certain extent, be provided in the form of grants. Alternatively, debt cancellation should also be considered as means of compensating developing refugee host countries. This would be a meaningful act of solidarity towards host communities. I'd now like to move on to areas of improvement of the GCR as it stands. So first and foremost, holding states accountable to their commitments through a robust reporting framework. States must have under the GCR mandatory reporting requirements to ensure the pledge's implementation and review. The GRF digital platform and dashboard that tracks the pledges and their implementation is a laudable effort by UNHCR to keep the ongoing global responsibility sharing effort transparent, but it is not a financial tracking or reporting tool. Updates are still based on voluntary reporting by pledging entities and recipient entities. And the value of self-reporting should not be underestimated, even where the pledges are not in themselves legally binding. Self-reporting can facilitate evaluation of a country's performance, public review and peer pressure, and guarantee procedural fairness. Secondly, we need transparent and refugee rights compliant partnerships. In the case where contributions to responsibility sharing take the form of joint pledges with partner organizations, be that the private sector or NGOs, the primary reporting obligation shall rest within the states, and the states shall share detailed information on the roles and responsibilities, the division of labor between the partners, as well as a guarantee that arrangements are in full respect of humanitarian and human rights principles. Now, if one were to reflect to what extent state pledges during the GRF in 2019 can be said to reflect their capacities and capabilities, this notion of responsibility by capacity, or even a fair share, well, global North countries certainly need to do more until it can be said that they undertake a fair share, not only because of their resources and capabilities, but also because of their externalization policies, particularly those that aim at obstructing legal access to territory in the global North. To conclude, although it is too early to assess the normative impact of the Global Compact on refugees as a soft law instrument on the development of international refugee law with respect to responsibility sharing, whether the compact can fill the responsibility sharing gap, the answer is that the GCR started an important international process, but a protocol that will codify an obligation to participate at least in responsibility sharing in international law has been and should be, as Assistant High Commissioner Gillian Triggs also acknowledges, the end goal of this international process. Thank you very much, and I'm looking forward to questions and comments.
Thank you very much, Elizabeth. And again, I think some very interesting points there about the potential, but perhaps some of the limitations on the GCR as we have seen it to date. So it'll be interesting, again, to see if our participants in the wider audience might have some thoughts on that and questions for you. I encourage them to post them. Let us move on then now to look at specifically the question of regional arrangements and their potential. I'd like to invite Riona Moodley, who's from the University of New South Wales in Australia and who is staying up late, I think, to take part in our panel today, who's going to speak to us on rethinking regional processing under the Global Compacts, looking at the Indochinese CPA, Comprehensive Plan of Action, as a roadmap for international cooperation. Riona, over to you.
Thanks, Madeline. The inherent limitations of externalization practices that are based on containment and deterrence, I believe, came to light woefully in 2015 in the Mediterranean and Andaman Seas, as thousands of refugees lost their lives in search of safety. A sobering lesson that should be drawn from that period. Sorry, I just have to turn the light on. It is getting quite late. A sobering lesson that should be drawn from that period and the present is this: no one state can insulate itself from forced migration challenges occurring elsewhere. There was then, as there is now, an international dimension to large-scale forced migration that warrants a coordinated international response. Since the adoption of the Global Compacts in 2018, it seemed as though states were prepared to address these failings, recognizing the global need to collaborate and to provide more comprehensive pathways to international protection and regular migration. 3 years on, questions remain over how the Global Compacts, in particular the Compact on Refugees, will translate in practice to respond to like situations. One option that has been raised and which I'd like to consider with you today is the possibility of expanded and targeted resettlement through a region-wide processing framework in key transit countries and regions of origin. This idea, which I refer to broadly as regional processing, envisages several states and other partner organizations engaging in a multilateral arrangement to process claims for international protection in a particular country or region that is or is at risk of being overwhelmed. Now, provided that such idea is implemented without prejudice to the right of asylum seekers to leave and seek asylum elsewhere, regional processing has the potential to address not only immediate humanitarian and protection needs, but it might also help remove the very real risks associated with onward movement by providing complementary pathways to protection. Of course, for any of this to work in practice, it would require international cooperation and firm commitments from all stakeholders to respect key human rights principles. Now, while this might sound like an unrealistic proposition in the current political climate, I would like to reflect on how a similarly ambitious plan known as the Comprehensive Plan of Action for Indochinese Refugees was implemented successfully just over 30 years ago when over 65 states collaborated to resolve the forced migration crisis impacting Southeast Asia in the 1970s and 80s. Now, while it was by no means a perfect response, the CPA provides valuable lessons on how the divergent interests of stakeholders might be reconciled to respond to forced migration situations. But before launching into these lessons, let me provide some brief context. The CPA had its initial beginnings at the end of the Vietnam War, when hundreds of thousands of refugees began fleeing Vietnam, Cambodia, and Laos to neighboring countries. 2 UN-led international conferences were called to respond to the situation. This involved bringing together a range of stakeholders, including donor and resettlement countries, countries of first asylum, the principal country of origin, Vietnam, as well as international organizations such as UNHCR and NGOs. While one of the principal aims of the CPA was to restore asylum to the region in circumstances where many countries were pushing back new arrivals, the CPA's overriding objective was to end the ongoing movement of asylum seekers by removing the need for it. To achieve this, the CPA implemented a comprehensive region-wide processing framework to enable refugee status determination to be undertaken en masse across Southeast Asia. Those found to be refugees were resettled abroad in countries such as the US and Australia. In return, countries of first asylum, including Thailand, Malaysia, and Indonesia, agreed to provide temporary protection to asylum seekers pending resettlement or voluntary return. These countries also assumed primary responsibility for undertaking RSD under UNHCR supervision. Rather remarkably also, the principal country of origin, Vietnam, became a crucial partner in the arrangement and began cooperating with UNHCR to repatriate those who voluntarily returned home on the basis that they would not suffer persecution. Vietnam and UNHCR also work together to disincentivize irregular travel by creating regular migration pathways out of country through its orderly departure program. The initial rollout was, however, fraught with a number of procedural issues. Inconsistent refugee recognition rates across the region prompted concerns of refoulement. Many asylum seekers were also held in closed detention, prompting, also the CPA's repatriation component was also heavily criticised for having countenanced the possibility of involuntary returns. Now, bearing these amongst other problematic aspects in mind, it should be noted that the quality of procedural fairness and the standard of regional consistency did improve over time due to UNHCR's supporting and supervisory role. Over the quarter century that the Indochinese crisis endured, over 3 million people fled their homes across the region. However, through the sustained international effort to resolve the crisis, approximately 2.5 million people were resettled elsewhere and 500,000 were repatriated. So what then is it that we can learn today from the CPA? The first lesson to be drawn is this: it is only through broad political engagement and the equitable sharing of responsibilities based on capacity that a truly comprehensive refugee response can be implemented to its conclusion. This, as the CPA demonstrates and the Global Compact's calls for, requires multi-stakeholder partnerships, including countries from within and outside the impacted region, international organizations, crucially UNHCR, NGOs, but also refugees and migrants themselves. Today, the Comprehensive Refugee Response Framework and support platforms under the Global Compact for Refugees provides a tangible framework and mechanism for states to galvanize support and to coordinate global efforts to respond to like situations. But perhaps the most critical lesson to be drawn from the CPA is this: for any future refugee response under the Global Compact to be sustained, it must be premised on a clear commitment by all stakeholders to respect international and human rights law principles. The CPA demonstrates how this can be practically achieved. Problematic aspects of the CPA did arise and would of course need to be corrected today. Ultimately, however, the CPA's sustained commitment to provide international protection and to respect human rights averted an unfolding humanitarian disaster. For any similar framework under the Global Compact on refugees to have the same, if not greater success, it too would need to put human rights protection first. The final lesson that I'd like to leave you with is that durable solutions are needed for all who travel irregularly, be they refugees or not. As both global compacts recognize, one of the most critical issues we are facing is the absence of safe, orderly, and regular pathways for international protection and migration. In this regard, the CPA was one of the first international attempts to provide durable solutions for both refugees and migrants. Of course, the CPA noticeably excluded local integration. To be truly comprehensive, future efforts should accommodate all three traditional solutions where it is safe to do so. This could be complemented also by drawing on the Global Compact on Migration to explore other migration pathways, including orderly departure programs akin to the CPA, as well as education and labour mobility programs. To conclude, what I hope to inject in today's panel discussion is some optimism for what is possible. Despite the CPA's unique historical context, it shares a number of parallels with the complexities of forced migration today. While states have a legitimate interest in managing such movements, actions taken to address them must be premised on a commitment to international cooperation, responsibility sharing, and most importantly, respect for human rights. Provided that these key pillars are respected, regional processing under the framework of the Global Compact on Refugees has the potential to offer real solutions for refugees and migrants during large-scale movements. It is also capable of sharing the so-called burden of responsibility disproportionately carried out by countries and regions of origin. This multilateral framework stands in stark contrast to the types of unilateral containment practices deployed in Australia and those now being considered in Denmark that serve only political interests. I believe the lessons of the CPA should not be relegated to the past. There's an opportunity to learn from them to create possibilities for the future that can, in reality, be both pragmatic and principled. Thank you.
Thank you very much, Riona. And I think that's a really interesting point you've closed on there regarding the potential for regional arrangements to increase scope for protection. Because I think indeed what we all see in different parts of the world, that there is scope to build on existing diplomatic and regional ties and structures in order to explore the potential for that. And regional standards in some senses, under some refugee law instruments, can also provide an important basis for that. So let's move now to our final speaker, and I'm very glad to welcome Sreetapa Chakrabarty from the Rabindra Bharati University in India, who's going to speak to us on externalization practice, the Global Compact on Refugees and the Rohingya refugee crisis, with a comparative analysis of externalization practices in Australia and Bangladesh. Sreetapa, you have the floor.
Thank you, Madeline. Can I share my screen? Can you all see my screen now?
We can. Go ahead.
Okay. Thank you. So in the contemporary age of mixed and massive flow of refugees across the globe, an important tool of neoliberal governance and neoliberal forms of migration management has been an increasing externalization of borders in the global north, which again have been reflected in the global south in recent times. Now, in this paper, I intend to comparatively discuss externalization practices, mainly offshore or extraterritorial processing in both Australia and Bangladesh in relation to the Rohingya refugee crisis. I further try to identify potential gaps in protection under the Global Compact on Refugees, henceforth GCR, that directly affect the Rohingya situation along the following lines: externalization of borders, responsibility sharing, and protection of the Rohingya in South Asia. And at the end, I try to explore some ways in which these gaps may be filled. Now, coming to offshore processing in Australia, I won't go into the details of the Pacific solution or the Australia-Cambodia deal. What I would like to point out is that all these incidents, first of all, reflect burden shifting rather than responsibility sharing. Secondly, all these incidents, which you can see on my screen, they violate the centrality of protection as enumerated in para 5 of the GCR, which guides the overall application of the Global Compact. These instances reflect forced return rather than voluntary repatriation in conditions of safety and dignity, as underlined in para 87 of the GCR. And considering, according to para 90 of the GCR, that resettlement is also a tangible mechanism for border and responsibility sharing, and burden and responsibility sharing, and a demonstration of solidarity. Support for voluntary resettlement in conditions of safety and dignity should be implemented. Now, coming to offshore processing in Bangladesh, relocation to Bhashanchar. Bhashanchar was basically formed from the Himalayan silt in 2006 to 2007. It is the current residence of thousands of Rohingya refugees who have been relocated under the Asylum initiative, which was revised in 2017 following the Rohingya exodus from Myanmar into Bangladesh. The Asylum 3 initiative, undertaken in 2019, worth TK 3,094.95 crore, involved the construction of houses for forcibly displaced Myanmar nationals, as they are known in Bangladesh, in Bhashanchar of Hatia Upazila under Noakhali district, and necessary security infrastructures for the island. So this figure, which you can see, it shows the enormous number of Rohingya refugees relocated to Bhashanchar since December 2020. These are some of the infrastructural arrangements which you can see, which the government of Bangladesh has made for the Rohingyas to make it more habitable for them. And semi-permanent shelters have been constructed for providing refuge to about 1 lakh Rohingyas, which can be expanded to 4 lakh in the future. But there are several hazards or several dangers of inhabiting Bhashanchar. That is, first of all, the island is vulnerable to floods, cyclones, and storms. There are food shortages, inadequate health services, there is no access to education, and there are innumerable restrictions on movement and a lack of livelihood opportunities. And although there is enough space for the free movement of the Rohingya, there is 24 hours CCTV surveillance, and by 2019, security was planned to be enhanced through the installation of 120 cameras, construction of perimeter fencing, and watchtowers, leading to what we can envision as the modern day panopticon. Other forms of abuses, as has been reported, which is shown in this slide. I found this report very interesting and very important. It has been released by the Human Rights Watch just a few days ago. So there are lots of refugee narratives here, and among the suggestions to various government and non-governmental bodies, this suggestion I take up in my concluding part on the GCR, that is the right to return for Rohingya refugees who have been displaced arbitrarily or unlawfully. They have been deprived of their former homes. And this you can see is the concept of prison, which has, or the panopticon, which has developed over the centuries. In the extreme left, you can see Bentham's and Foucault's structure of prison. And in the middle is the refugee transit center in PNG, and in the extreme right is the refugee resettlement area in Bhashan Chor. Now, coming to a comparative analysis of externalization practices in Australia and Bangladesh, some similarities are pushbacks and offshore processing. However, there are wide gaps in externalization practices between Australia and Bangladesh. For instance, Australia is a signatory to the 951 Refugee Convention, and Bangladesh is not, which makes the situation further complicated. Further, refugee status determination process that differs in both these countries. In case of PNG, there is a little bit developed system of refugee status determination, including the PNG Migration Act of 1978, which deals very briefly with refugees and asylum seekers in the country, their status. But in Bangladesh, there is no legal framework of refugee status determination or of defining refugees. Rather, Rohingyas are not considered as refugees in Bangladesh. Then you can see the structure framework leading to externalization. In case of Australia, we all know there have been memorandums of understanding. There have been the Australia-Cambodia deal, Operation Sovereign Borders. But in case of Bangladesh, it has been a prerogative of the sovereign state as of now. So these are some of the difference factors in the externalization practices. Now, coming to the crux of my presentation, why are we calling the Global Compact on Refugees one step forward and two steps back? First of all, the compact does not provide any durable solution towards achieving predictable and equitable burden and responsibility sharing. Rather, in reality, facilitating access to actual or durable solutions has meant expanding access to third country solutions. And this seemingly fulfills objective 3 of the GCR, but in reality, it has indirectly encouraged externalization and shifting burden towards developing nations. And secondly, it is silent on non-signatory states to the 1951 Refugee Convention. It only says that all countries who are not yet parties to the convention are encouraged to accede to those instruments in para 6 of GCR, and it reflects a non-recognition of the regional specificity of the refugee situation and externalization in South Asia. So it contradicts its own recognition of significant regional, sub-regional dimension, as we can find in para 28 of the GCR. Thus, the Global Compact appears to be somehow an apparatus of power in itself, as it fails to be global after all. And with reference to the GCR objectives outlined in para 7, it may be seen that easing pressure on the host countries indirectly hinted at countries of the north and not south. For instance, Bangladesh hosts the largest, despite an overpopulated country, it has provided refuge, and it currently is providing refuge to the largest number of Rohingya refugees. Thereby, it makes the compact makes the equitable burden and responsibility sharing extremely unequal in nature. Secondly, enhancing refugee self-reliance has implied increasing dependence on the market. And here I come back to my introductory line where I was talking about externalization as a neoliberal tool of migration management and governance. Expanding access to third country solutions has meant shifting burdens to countries of the South, as I mentioned before, and returning refugees in safety and dignity has often been forced return. So it talks vaguely about safe return without moving towards any condition or any change in conditions for safe return, as in case of Myanmar. So while concluding, I would like to quote UNHCR here, saying that it is ironic that as we celebrate the 70th anniversary of the Refugee Convention, attempts are being made to weaken its principles and spirit. Instead, the priority must be to find more effective ways to guarantee the universal right to seek asylum and other rights provided by international refugee law. So what I think is that apart from easing pressure on countries in South Asia like Bangladesh and involving the Rohingya as relevant stakeholders in consultation processes, or taking up the issue of externalization and Rohingya refugees in the future global refugee forums, which my friends were also talking about in their presentations, they mentioned about it. So apart from these, I think emphasis should be, or emphasis can be put on voluntary resettlement apart from voluntary repatriation, and the right to return in conditions of safety and dignity can be prioritized. So I am hopeful of the GCR. The GCR can pursue these objectives, keeping in line its concept of the centrality of protection of refugees. And I'm looking at statelessness from a post-colonial perspective. So I'm emphasizing internal as well as external stateless. The Rohingya are not only stateless all over the world, they're stateless within Myanmar as well. So therefore, if we think about voluntary resettlement, we have to think in terms of settlement first in their country of origin, and their right to return in conditions of safety and dignity. Now, as we know, Myanmar's national unity government, it has recently drawn a charter focusing on or pledging towards Rohingya citizenship. Now, whether that will happen in reality, or how much time it will take, or whether it's just for a temporary political purpose, that we don't know. But in this condition, pressure from the international community may be exercised along the principles in the GCR to achieve these desired objectives. So the GCR has enormous capabilities in spite of falling short of protecting the refugees in South Asia. Thank you. I would like to end my presentation here.
Thank you very much, Sreetapa. I think really that's given us a very rich source of information about the current challenges around protection of Rohingya refugees, as well as some important issues of principle to consider. Perhaps I can say just one thing, of course, in terms of distinctions between the Bhashan Char situation and that of Australian PNG, of course, is that Bhashan Char is clearly part of Bangladesh's territory, so there can be no question of the state responsibility, of course, for standards there. And naturally, Bangladesh's human rights obligations nonetheless remain very pertinent to this discussion, leaving us, even though, as we know, it's not a party to the 1951 convention. So very interesting questions now starting to come up in the chat. I'd now like to go back to our panelists and invite them to respond to some of these. We'll go in the order with which we began the presentations. So turning first to Emilie. And Emilie, you've got a few interesting questions and thoughts that have been put in there. So I'd invite you perhaps to respond to some of these. We've had questions about the potential for the greater protection of the right to live in regional systems, given potential justiciability in some regional forums. Questions about strategic litigation and how that might potentially contribute to enforcement of the right to leave, and other ways of operationalizing or enforcing that right. So please, Emilie, we'd be glad to hear your thoughts on those questions.
Thanks so much, Madeline, and thanks everyone for the really interesting questions. They're quite similar, so I'll try and answer them relatively collectively. So in terms of the justiciability, I would say that in terms of regional systems, whether it's the Inter-American system or the European Court of Human Rights, the African system, obviously the European Court of Human Rights has quite a substantial number of cases on the right to leave, perhaps not substantial in comparison to, say, non-refoulement, but it has considered a number of cases on the merits and developed quite a guiding framework for the right to leave. But unfortunately, other than in a case concerning a travel ban, it hasn't commented on externalization with regards to the right to leave. And in this regard, I think it was a real shame that in the pending case against Italy, SS and others against Italy, that was recently communicated, that concerned responsibility of Italy for pullbacks by the Libyan Coast Guard, the right to leave was not argued and was not pleaded. So I think in terms of strategic litigation and thinking about future advocacy, while there are cases on the right to leave, as I said, there are not many being raised in regards to externalization. We have a couple before the Human Rights Committee coming up that have been where the right to leave has been pleaded, primarily in regards to cases against Italy and Malta. However, I think this is a really important opportunity that where something quite squarely obstructs departure, such as pullbacks, that's quite a, you can't think of a more paradigm case in the externalization context of a violation or an infringement of the right to leave. So it's really pleading the right to leave and showing that it's relevant to this context, and not, I think, always only focusing on non-refoulement, because the right to leave protects everyone. So I think that's a really important part of the litigation strategy is to think about where it can actually be raised. And coming to, Cameron's point in terms of the jurisdictional issues, obviously there wasn't a question there, but just to comment on that, I believe in the SS in Italy case from people I spoke to who were bringing the case, that one of the reasons they didn't necessarily want to raise the right to leave was because they were already making quite a potentially contentious jurisdictional argument in terms of trying to establish Italy's jurisdiction over the conduct of Libya there. So I think that, again, we would need to be pushing for an expansive understanding of jurisdiction before the European Court of Human Rights, but the Human Rights Committee is well on the way to have it. I would say that it would accept that pullbacks are quite clearly falling within this jurisdiction of Italy there. In terms of Nick's question on domestic laws, I haven't looked specifically at domestic laws. Of course, there are sporadic cases on passport denial and that kind of thing. But I think delving into the domestic laws on the right to leave would be an important part of the litigation strategy, to see if the cases concerning the right to leave are being brought there to begin with. But of course, in the context of Australia, if we're thinking, if we take it potentially out of the externalization context to thinking of, say, COVID and the fact that Australia has a ban on outward travel, and we think of that with the right to leave, there's no domestic forum for Australians to bring a human rights case such as that. So really then we're left with the Human Rights Committee. So I think many constitutions, I think there's over 100 do protect the right to leave. So I think it's part of, a toolbox of sometimes going through the domestic avenue, other times would need to be going to the European Court of Justice. There have been cases recognising, and this goes to, I believe, Mariana's question. Yes, the EU Charter does not explicitly protect the right to leave. However, it's recognised as a general principle of community law, as well as protected under EU free movement more broadly, the right to move and reside. But I think, going back to the main point, is that we really need to be utilising regional bodies, ECOWAS, the East African Court of Justice, as well as domestic bodies where they're available. And I'll leave it there, but happy to discuss anything else further on this.
Thank you very much, Emilie. No, I think that there are really some important points made there. And you, of course, have brought to our attention the pending case of SS against Italy before the European Court of Human Rights, which indeed is going to be very significant, I think, in terms of clarifying legal norms, at least within the EU framework, the Council of Europe framework as regards externalization. So we look forward to seeing that judgment in the relatively near future. I'd like to turn now to Elizabeth, if I may, and there's been some questions that have been posted there for her. One in particular, which I think is of interest to many of us, around the question of community sponsorship, where Nick has highlighted the fact that there may be cases indeed where this isn't politically feasible, and what you think then of its merits notwithstanding. Perhaps I could just add to that, abusing my role as chair, just to say that, of course, it's noteworthy also that whilst community sponsorship does involve important actions by non-state actors, communities offering to host people, it nonetheless still involves a grant of a right to enter and to stay on the part of the state. So that's certainly one important aspect of it. And if I could then, perhaps I could also pose my own question to you, Elizabeth, because I think you've rightly pointed to the importance of ensuring that the pledges made at the Global Refugee Forum in 2019 are going to in fact be implemented, and the importance of a strong reporting or accountability mechanism in that regard. I'd welcome your thoughts on what UNHCR could do to ensure that the upcoming high-level officials meeting that is foreseen for the end of this year, at the midpoint between the two global refugee forums, what can be done to make sure that that's a place where we, in addition to welcoming progress that's been made on implementation of pledges, where we could really highlight the importance and exert pressure on those state actors in particular that need to do so to deliver on their pledges as regards responsibility sharing. So Elizabeth, over to you.
Thanks, Madeline, for your question, and thanks, Nick. I'll start with Nick first. So when the political feasibility is not, well, there is no political feasibility. Of course, we need to work with the tools we have, and I do believe that community sponsorship, as I said, is an important complementary tool for responsibility sharing. But I would favor a principled framework for community sponsorship. I'm not aware that it exists at the moment, but we need to have a principled framework, even for private and community-led sponsorship. But even if it is an academic, for example, scholarship or an employment contract for this case, still when that contract ends or the scholarship ends, still the states needs to come in. It's for me, this is the important part of having the state acting as a primary actor for international protection. Secondly, my fear with community-led sponsorship, which I alluded to in my presentation, is more generally how I see asylum as an institution being shrinking, particularly in the global north. And I fear with a lot of focus of very well-intended community-led sponsorship, which, as I said, is really needed. I fear that asylum is losing ground, and the Refugee Convention rests on asylum as an institution to provide international protection. But if I may say, we are in the political sphere currently, since responsibility sharing is not codified in international law. So we are operating in the realm of politics, and therefore we'll have to work somehow to foster political will and even convince and persuade states to do more in terms of resettlement, which they are doing. At least before COVID-19, there were some pledges as well. We don't know what's going to happen, but it doesn't seem to be fair on the one side pledging resettlement places and on the other side building walls or thinking of offshore processing. And it's not only Denmark, it's also the UK currently, that the Home Office is currently considering extraterritorial or offshore processing. Now, if I turn to Madeline's questions, I believe that states under the GCR should have a requirement to report, and even if it is not on the compact, it can come through maybe the high level segment or through any other. But UNHCR needs to urge states to report. If we see also in another area of collective governance, which is in the climate change, and which the Global Compact obviously has cross-fertilized quite significantly, states have to report. Even if the pledges are non-binding in nature, they do have to report. And if they report, there will be a process of peer pressure and assessment, and we can see, and the international community can see whether states do undertake their fair share, so to say. And I'm aware that in the draft of the Global Compact on Refugee was proposed for states to undertake a normative requirement to justify their pledges in light of their fair share. However, it was rejected and declined by states, which is a shame, because that would operationalize what we see as a differentiated responsibilities framework more prominently. So I think if the compact aims to track pledges and contributions, UNHCR's reporting is not enough. We need to have states, because even by doing this self-assessment of reporting, it will put states in place of actually holding up to their commitments. And if I may quickly add some, I'll actually share my comment on the regional free movement frameworks that I think, Madeline, you posted to all of us. I do think that we need to consider when we talk about free movements on who is free to move, because in the EU, only the EU member states are free to move, and very recently the UK as well, but still they're free to move. So we're talking about the global north is being able to move. But in African region, for example, it used to be a continent and still is of much more fluid borders. And there was a lot of free movement before states. And borders are perceived differently in different areas of the world. And when we condition, for example, free movements in Africa with migration partnership managements, then we try, this is what I think Sreetapa would refer to a neoliberal how can I say, tactics to impose to other regions. And the problem that we see is that the movement is free, but is conditioned to certain passports and not others. And I think if we want to be honest and critical, this is what we see happening. And I'll stop here to let the others as well contribute. Thank you, Madeline.
Thank you very much, Elizabeth. Very, very helpful. And thank you for the suggestions to UNHCR. I'd like to turn to Riona now. And Riona, you've got a couple of interesting questions posted as well. One that invites you to expand on your thoughts around the role of Vietnam under the CPA arrangements, given importance also today of discussions around what is needed from countries of origin of refugees as part of the search for solutions. And then there's a second very interesting question about your views on the fact that today we have relatively few countries in the region that are contracting states to the 1951 convention, notwithstanding the very significant contribution to protection and solutions that Southeast Asian countries made during the CPA era. So please, we'd welcome your thoughts on those. Thank you.
Oh, hi, sorry, just am I unmuted? Okay, thanks. No, so first to Nick's question, yeah, it is really interesting. Vietnam's partnership was actually quite critical because due to the politics at the time, countries within the region were not prepared to locally integrate any of the asylum seekers. And so the question arose, well, to the extent that refugees were screened and people were screened out, what was going to happen? And so Vietnam's involvement, particularly in the repatriation aspect, was critical to the success of the CPA arrangement. And that was largely incentivized through economic and political gains, because this was now after decades worth of war within the region. Vietnam was economically obliterated. It needed to now re-engage with the international community. And that was part and parcel of the leverage, I suppose, that was had between Vietnam and other states in terms of cooperation and at least allowing Vietnam to engage in not only the repatriation regime on the basis that it would not persecute those asylum seekers who were returned. And of course, UNHCR was also heavily involved in that process of monitoring and supervising that. And there were lots of economic grants given to asylum seekers who returned as well to locally integrate. There was also significant amounts of money put into Vietnam to help with its economic rebuild post the war. So these were part and parcel of this multi-stakeholder relationship and this push and pull in terms of balancing relevant parties' interests. The orderly departure program was again a really critical aspect and development of the CPA program, because of course, in order for the resettlement arrangements to work in countries of first asylum, they needed to stem the number of asylum seekers who were traveling irregularly. And the only way that they realized they could do that was to provide real solutions for people within Vietnam to leave through regular pathways. And so that was a critical part of the arrangement. And of course, Vietnam agreed to work with UNHCR to effect that. There were, however, a number of criticisms raised about the orderly departure program, which I think would also need to be considered given the relevant political context and of the movement that's occurring within a particular country of origin. at the time, Vietnam was accused of potentially using the ODP program of facilitating the exit and cleansing the country of its ethnic minority, Chinese minority. There was also issues raised regarding the extent to which the orderly departure program interfered with the right to leave. So these were issues that were being discussed throughout this process of facilitating refugees to, asylum seekers to leave the country through regular channels. Yeah, so it was this multifaceted arrangement, but I do think it does have a lot of lessons, I think, in terms of the balancing act that one has to play when dealing with the country of origin. And of course, repatriation was another issue at the end, towards the end of the CPA. Because there were concerns around forced repatriation, where a number of countries were at the end decided to forcibly return some of the asylum seekers in their countries. So that's on the role of Vietnam. I did think about this in the context of the Rohingya and a discussion that I was having with Sreetapa about repatriation and how could we possibly leverage, for example, the commitments made in the global compacts in circumstances where a number of the Rohingya who are now in Bangladesh have been pushed out by, of course, Myanmar. But to what extent could we engage with Myanmar at a certain point in time to facilitate the repatriation of those who want to return, but to ensure that their safety is protected? You know, what would be needed for that? And I think that's a really interesting, I don't have the answer for that, but I think it's a really interesting point to think about, because I think often from a global north perspective, we tend to think of repatriation as quite a bad alternative or durable solution. But there are numbers of refugees who want to return home, but cannot, because of the political situation. And so the question is, how can the international community work with the country of origin to place political pressure on them to accept those who wish to return and to ensure that they are not persecuted further? You know, so those are the tough questions I think that we're going to have to deal with in the future. But yes, of course, the Vietnam's role is certainly an interesting one and an interesting example. I might turn to the second question referred to, I think raised by Patricia, just regarding why it is that the Southeast Asian region has not really ratified the convention. And there does seem, and to this extent, the CPA has also been criticized about leaving a legacy of temporary protection within Southeast Asia. I mean, the reason for why a number of countries of first asylum declined to locally integrate had a lot to do with the politics at the time. I mean, those countries were also ravaged through war. They were also struggling economically, and at a certain point, a number of the countries within that region had said, no, we're not going to accept any more people. And then they started taking forcible action to do that. But through this push and pull, an arrangement was finally agreed to provide temporary protection. But yes, there is this issue of the legacy of that decision, because you know, efforts to locally integrate are quite challenging within the region. And that does seem to be, I think, I suppose, one of the negative aspects of the CPA arrangement and its legacy.
Excellent. Thank you, Riona. Very interesting. So now let's turn to Sreetapa, and there's a couple of interesting questions there as well. Sreetapa, the first relates to your point regarding voluntary resettlement to third countries, as you mentioned it. And I think I'd particularly also be interested to hear about that, because of course, I think from UNHCR's viewpoint, at least, resettlement, as it's usually referred to, involves the offer of refugee protection and a right to stay in third countries that is in practice and needs to be voluntary as regards the refugees' viewpoint. And we have distinguished that very clearly from externalization practices that could involve involuntary transfer of refugees to another country where they don't have sufficient safeguards. So, I mean, it'd be interesting, I think, to hear your thoughts on what is the potential then for voluntary resettlement as you've framed it. And I think then Riona's also raised an interesting question to you as well regarding repatriation and scope for us to think about ways to support that indeed in cases where it's genuinely voluntary and where, as in many parts of the world, in many refugee crises, we see so many refugees who really would love, above all other things, to return home in safety and dignity. So thanks for your thoughts on that. Over to you.
Thank you so much, Madeline. Actually, with regard to both the questions, I would regarding your question on safe movement, that's a regional framework on free and safe movement, and the question on repatriation and resettlement. I would just turn a little back to history. That is when after the Second World War, countries in Europe were dealing with refugee crisis, and they were up to framing the Refugee Convention. Countries in South Asia, especially my country, so they were dealing with the looming crisis of partition. So the entire, the horrors of partition which our forefathers have experienced, or which the Indian or the South Asian subcontinents have experienced. So I think, first of all, a great challenge is that safe and free movement is a paradox. Let's just, if to say, this is the reality, safe and free movement is a paradox in most of the countries in South Asia. Okay, now how voluntary repatriation and voluntary resettlement would work in practice. So currently Myanmar is under, as we all know, is under a coup. So here the only option we have is, even if the GCR is not binding upon the states, as Elizabeth was saying, of collective governance, states have to report, even if GCR is not binding in nature. So there, I think it's a challenge for UNHCR, because Madeline would agree with me how difficult it is to work with Myanmar right at this point, because their own citizens are not safe. Recently, even in yesterday's panel, Jay was talking about the Nandita Haksar case in India, where non-refoulement has been, recognized as a part of the right to liberty, which is enshrined under Article 21 of our Constitution, under the Indian Constitution. So that, I think, that is with regard to the Myanmar nationals only. Okay, so when their own citizens, they are, fleeing that part of the country. So now we are talking about the Rohingya, who don't have any identity. Stateless cannot be an identity, right? So it's again a paradox that those who do not have any identity, say, PNG or externalization or Bhashanch or whatever I was talking about, those who do not have any identity, they are put to another place, and then let's see, after 5 or 10 years, what they will be referred to. They will be referred to as refugees, they will be referred to as residents of that place, or they will be referred to as Myanmar nationals. So the situation is extremely complex and intriguing, but I think the GCR has the potential in collective governance, in pushing the frontiers of the neoliberal governance, which I was talking about, and which Professor James Hathaway was also talking about yesterday, that hosting refugees is a responsibility and not a burden. So similarly, having one's own, on the ground of jus solis, if we see that I am born in this soil, and therefore I should get the citizenship, and if at least not citizenship, I should get the minority status. They are not even included in the 135 national ethnic minorities of Myanmar. So until and unless that is done, so that is the first step towards repatriation. Otherwise, in this condition, I don't think the Rohingya will feel safe at all, because most of them, they want to settle in Bangladesh also. They do not want to go there. They are some, many of them marry some Bangladeshi citizen. Then they have children over there. So as Riona was saying, where it is voluntary and where it is safe to return. That's the most important part, not only safe and voluntary repatriation, but safe and voluntary resettlement. And therefore, whenever in like the majority of the concepts or wherever I read about externalization, they talk about resettlement in a third country. But I don't think that's a durable solution. Because again, from that third country, those at least which has happened in case of some of the Rohingya, they're fleeing from that third country also. They're not feeling safe there. They are not treated properly there. So I think durable solution lies in the country of origin, and these are the few intricacies which I talked about. So here, I think the GCR has the potential to take it further, bordering on citizenship, obviously, and their refugee status. Thank you.
Thank you, Sreetapa. No, I think that's an important point that you've raised there, that indeed the GCR, of course, talks about access to solutions. And a part of that has to be local integration in some cases. But statelessness is also a critical issue arising here that needs to be addressed, indeed. And you said that Rohingya are seen as not having an identity, but they certainly have rights. And indeed, addressing their statelessness in the longer term has to be a key goal as well. We've nearly come to the end of our time, everyone. So I will come back to our speakers and then give them 1 minute each just to say a final word in a minute. But first, I should address the question that has been put to UNHCR by Nick regarding externalization. And this is a very welcome one, because indeed Denmark has contended its proposal enacted in law on the 3rd of June is lawful. And Nick asks whether HCR foresees situations in which an externalization proposal could be lawful and consistent with the spirit of the 1951 convention. And on this, I should say UNHCR, in its note on externalization that it published at the end of last month, has explicitly defined externalization, which of course isn't defined in international law, as being an arrangement which directly or indirectly prevents asylum seekers and refugees from reaching a particular destination country where they are able to seek and enjoy protection. And this is an arrangement which involves inadequate standards and burden shifting. So by definition, UNHCR characterizes current externalization proposals as being proposals that are problematic in terms of law because they don't include sufficient safeguards to ensure people can get access to protection. We do, however, recognize there may be situations where lawful transfer arrangements may exist, provided these do guarantee adequate standards of treatment and access to procedural and other standards that can be enforced to ensure that asylum seekers and refugees can have access to protection where needed and to a durable solution. I should say that as regards the Danish proposals as they stand, we don't see the evidence at this stage that they do contain sufficient standards and sufficient guarantees to ensure that the rights of people concerned will be respected. And so we are continuing to be very concerned about that proposal, and we'll be monitoring it closely to see how it progresses further now that it's formed a part of Danish law. But let me then go back to our speakers. So 1 minute each. First of all, to Emilie. Let's hear from you.
Thank you so much, Madeline, and thank you everyone for their really, really interesting contributions. I just wanted to add to conclude that while obviously complement pathways, resettlement are obviously extremely important, and I think this is what is necessary to reduce the risk of unsafe travel and to actually help states fulfill their aim in terms of effectiveness and suitability to actually reduce unsafe departures, reduce irregular migration, is to open up those safe and legal pathways. However, I think that in terms of thinking about the right to leave and the right to seek asylum, even with complementary pathways, that does not negate the right for people to leave spontaneously, to leave when there is imminent risk. And I think we have to think about how some of these solutions themselves, we don't want to then reproduce solutions that also foster containment. So, you know, making people wait in host countries for a long, long time. We also still have to respect the right to leave to seek asylum. And I'm very interested to continue the discussion that we've had with the other speakers here, especially on this idea of the orderly departure programs, and you know, how is this something historical that could be replicated? Thanks so much, everyone.
Thank you, Emilie. Elizabeth, over to you.
Thank you, Madeline, and thank you all for the questions and for this wonderful panel. If I can conclude, I would like to highlight that when we talk about fair and equitable responsibility sharing, we must bear in mind that we should not use the word fair only perfunctory, such as fair and equitable responsibility sharing. We must have a conception, and even more so a vision, for fair responsibility sharing at the international level, not only towards refugees who are the beneficiaries of international protection, but also towards states. This is a state's responsibility under international law, and if states don't feel and don't perceive that they're being treated fairly, the only thing we will see is international protection being deteriorating and access to asylum also being restricted. And perhaps as food for thought, we might want to consider how international law can be part of the vision towards a fair and equitable responsibility sharing by moving on from the political realm of responsibility sharing and bringing it in slowly and gradually within international law. Thank you.
Thank you, Elizabeth. And I'm mindful of your point earlier that it remains to be seen what impact the Global Compact on refugees will have on the development of hard law in the longer term, the subject of another panel yesterday. So very interesting to see that in the future. Riona, over to you.
Hi, I suppose my concluding point would be that I think there's real value in us as refugee law advocates wanting to actually engage constructively with state interests, but in a way that helps direct state practice. And so the reason why I'm quite interested in the CPA is because it presents as a tangible framework that was implemented, I suppose, against a lot of odds. And whilst I know many have considered the CPA to be, very context and historically, politically specific, and consider that it might not be, replicated today. I tend to disagree. I think that if there is a large movement, so for example, during the Syrian refugee crisis, at the height of it, I think there was a real opportunity that was missed for states from within Europe, as well as the broader region, who were more adversely impacted by the direct impacts of the movement, as well as refugees, to have collaborated to really respond and address. And I feel like that was a real missed opportunity. And the CPA framework, at least, and I by no means think it should be wholeheartedly replicated, and I don't think that is not what I'm suggesting. But there are real lessons to be learned about how international cooperation was galvanized, practically speaking, and how those negotiations were had at the table to come up with this multifaceted, interlocking commitments that ultimately were non-binding, but because each relied on each other, it did successfully bring an end to that crisis. So what I'd like to just do today, and my hope is just to allow us all to reflect on some of the successes of the CPA and to consider, well, could we have something similar in the future? Thank you.
Thank you, Riona. Sreetapa, your last word.
Thank you so much, Madeline, and thank you for such an excellent discussion. I just popped up, or I just raised some of the few important conflicts and questions today. I myself don't have proper and perfect solutions to everything. But what I could say is that the UNHCR and the GCR, they have immense potential to address all these challenges, and therefore I talk about resettlement in the country of origin and not in third countries. And as Madeline said, that the Rohingya may not have any identity, but they are humans. They do have certain inalienable human rights, which I think can be addressed in future. And responsibility sharing, again, not as a burden, and but as as a willful action on the part of states. That is what is needed. And the task of putting pressure or galvanizing movement, I think that lies with UNHCR, and I have immense faith there. So I'm hopeful, and I'm willing to engage in more discussions with my fellow panelists, with Madeline in future, like what can be done regarding this. Thank you.
Thank you, Sreetapa. And let me just say also, of course, that HCR relies on its collaboration with its many partners, including in the non-state arena, and academic partners make a very important contribution to that too. So it's crucial for us to be able to have the opportunity to dialogue with you in a forum such as today. And it's been really a pleasure and a privilege to take part in this discussion. We've gone a bit over time, but I hope all of the participants agree it was well worthwhile. I, for one, have learned an enormous amount, and I really want to pay tribute to all of our speakers today who've done a great deal, I think, to make us all think about things in creative and different ways. So looking forward to continuing the discussions and further work on these important issues. Let me thank also our participants who have contributed in the chat. We hope all of this has been useful and valuable to you. And as I mentioned earlier, I do encourage anyone who's interested in the externalization question in particular to consider becoming involved in the working group on externalization within the Refugee Law Initiative, for which Nick Tan is responsible.